IGP, through the investigating officer, has moved this court via the notice of motion dated 3rd August 2026, seeking custodial orders to detain the respondents hearing Angela Mulwa and Nelson Masiga Makaralu for 21 days to facilitate investigations into a case of forgery of a document of title to land, theft of 4 motor vehicles, and malicious damage to property in connection to the death of one Dr. Victoria Mutiso, who was brutally murdered on the 29th July 2026. The prosecution deposed that the deceased, Dr. Mutiso, via OB number 52 of the 4th May 2026, reported that on the 12th day of February 2026, the matrimonial home situated at Mlolongo was raided, demolished, and valuable items stolen, including motor vehicle registration KDU 799 Range Rover Sport, which was recovered at the first respondent's premises. The prosecution alleges that investigations into the murder of Dr. Victoria Mutiso are at a critical stage by the homicide team, and so far 2 suspects have been arraigned at Milimani Law Courts. It is further alleged that 2 of the stolen motor vehicles are owned by AfriMep, an institution co-founded by the deceased and her husband, Professor Ndetei. The IO states that the 2 respondents herein need to be subjected to the process of forensic digital identification, and in terms of review of CCTV cameras and their communication network with the other suspects who have been arraigned before the court. Additionally, the remaining 3 vehicles and other missing items are yet to be recovered. The prosecution is apprehensive that the release of the respondents at this stage is likely to interfere with witnesses known to them, jeopardize ongoing investigations, and compromise recovery of further exhibits. In that regard, the investigators seek to establish the nexus between the respondents, the recovered vehicles, and the murder. The respondents, through the counsel, Mr. Mbeta and Mr. Omari, oppose the application and submit that no sufficient basis has been laid to warrant their continued detention. Counsels argue that there is no connection with the murder case, as the issue before this court is that of alleged theft of motor vehicles, that the prosecution has failed to place before this court any material to prove any interference, real or perceived, by the respondents. Counsel stated that the first respondent herein is a daughter to Professor Ndetei and is only being dragged into the issue of their parents having been divorced several years ago. The defense asserts that the constitutional right to liberty should not be curtailed merely because investigations are ongoing, and they urge the court to decline the application in the alternative to grant conditional orders which they are willing to comply with. I have considered the submissions by both parties. The issue for determination is whether the prosecution has established sufficient grounds to justify custodial orders for 21 days pending completion of the investigations. The issue for determination is whether the prosecution has established sufficient grounds to justify custodial orders for 21 days. Article 49(1)(f) of the Constitution guarantees every arrested person the right to be brought before a court as soon as reasonably possible, while Article 49(1)(h) provides that an arrested person is entitled to be released on bond or bail on reasonable conditions unless there are compelling reasons not to be released. Although this application concerns custodial orders before the respondents have been charged, the court is nonetheless obligated to safeguard the constitutional right to liberty under Article 29, while balancing the public interest in effective criminal investigations. I have quoted some 3 cases which I'm sure you're aware of, so I'll just go to the analysis. The court has carefully considered the affidavit evidence together with the rival submissions. The burden rests squarely upon the prosecution to demonstrate why the respondent's liberty should temporarily yield to the interest of justice. Unlike an application founded upon the seriousness of the offense, the present application is supported by specific investigative concerns. It is undisputed that vehicles alleged to be connected to Dr. Victoria Mutiso were recovered in the possession of the respondents. Whether such possession ultimately establishes criminal culpability is a matter reserved for trial. At this stage, however, the court is only concerned with whether the continued detention is necessary to preserve the integrity of investigations. The investigating officer deposes that forensic examination is yet to be concluded. The vehicles themselves constitute central exhibits. The investigators further state that they are tracing the chain of ownership, communication between suspects and movement of the vehicles, and possible involvement of additional persons. These investigations are yet to mature. The prosecution has also expressed apprehension that release of the respondents may result in interference with witnesses. While allegations of witness interference must ordinarily be supported by concrete particulars, the court notes that the investigations concern serious offense involving multiple persons, that the several witnesses may be required to record statements if need be. The affidavit indicates that the respondents are likely to know some of the witnesses. In the circumstances of this case, the apprehension by the prosecution cannot be dismissed. Equally persuasive is the prosecution's assertion that further exhibits remain to be recovered, where investigators have demonstrated that recoveries are ongoing and that suspects are believed to possess information capable of leading to material evidence. Temporary custodial orders may be justified provided they remain proportionate. The court is alive to the fact that custodial orders should never become a substitute for diligent investigations, as the investigation agencies are under constitutional obligation to conduct investigations expeditiously and efficiently. The court must therefore ensure that detention authorized is no longer than is reasonably necessary. Although the prosecution seeks 21 days, it has not sufficiently demonstrated why the entirety of that period is indispensable. The constitutional imperative under Articles 24 and 49 requires the court to adopt the least restrictive limitation compatible with achieving the investigative objective. In my view, the interest of justice would be adequately served by granting custodial orders for a shorter period. Accordingly, I make the following orders. The prosecution's application succeed in part. The respondents, Angela Mulwa and Nelson Masiga, shall remain in lawful police custody for 14 days from the date hereof to facilitate completion of the specified investigations. During the said period, the investigating officer shall ensure that investigations are conducted expeditiously, diligently, and without unnecessary delay, the period for detention having been granted solely for that purpose. This matter shall be mentioned on the 19th of August, being upon the expiry of the custodial period or earlier if investigations are completed, for the prosecution to report on the progress of investigations or for such further orders as the court may deem fit. For avoidance of doubt, the court emphasizes that these custodial orders shall not be construed as a finding of guilt, as the respondents continue to enjoy the presumption of innocence guaranteed under Article 52A of the Constitution. That is the ruling of the court.